Am I now audible?
Yes, ma'am.
Huh. Uh, the point is that now why this particular case has become very landmark, and I said on two counts. One is that the jury system has been dispensed with after this case. Number two is that consent. Under what situation the consent is obtained, that matters, and accordingly the rape law has been modified and amended to accommodate these kind of abnormal situations. So on these two counts, whenever somebody asks you about 375, you should also tell the backdrop story and then why there is a need for amendment, and then what was the case all about, that you may have to mention. Now, a 375 case section is such an elaborate section, and widely it is been described, and then what are all the conditions, firstly, secondly, fifthly, like that they have given almost seventhly. So those situations, then somebody is trying to do some act, some sexual intercourse, then it amounts to rape is what is given. Now, who are all the authority? Whether the husband can we say that he can commit rape and all? Whether any intercourse committed by him, can that be construed as rape and all, is very clearly given. Now, we were also talking about the judicial separation. Now, judicial separation, you need to understand, it is something different from divorce. But then, whenever a couple go for a divorce, no, the courts will use their prudence and they'll say, before we grant you the divorce, because divorce is a permanent thing, isn't it? That's also a decree, but then that's a permanent affair. Now, before that, they say a cooling time, that means in haste and in anger and in confusion, we may take wrong decisions. So what they think is, if we allow them to ruminate, and then allow them to give some time, probably their conflicts will get resolved by themselves. Time will heal everything. That's the concept the court believes in. So what they grant is not divorce, but then instead they grant what is known as judicial separation. Now, judicial separation means the couples, they will not get divorce, but then for 1 year or so they live separately, and then during that period, if somebody is the husband goes and then without the consent of the wife, though she is living separately and all, not living with him, but then he goes and he'll have intercourse with her, so that will also amount to rape, whether she is separate or under the decree of judicial separation. Irrespective of that, when she is living separately and without her consent, if he goes for intercourse, then that also amounts to rape, is what is given in these categories, firstly, secondly, those categories, it's also been given. Now, the what should be the qualification of a consent is given under again explanation. Now, it says consent means an unequivocal, there should not be any ambiguity. Unequivocal means no ambiguity. So no ambiguity, and it should be voluntary. That means it should come from her without any pressure and all. It should come from her exclusively, voluntarily, without any pressure or so. And agreement, when the woman by words. So what are all the ways in which she can communicate that consent is given in the explanation too. It says, when the woman by words, verbally she may communicate, or she may give some signs or gestures, or any verbal or non-verbal communication. If she is doing this, and if she is communicating her willingness to the by means of these methods, then it is construed as a sexual act. That's what is given under explanation 2. Now, provided that the woman who does not physically resist the act of penetration shall not, by the reason only of that fact, be regarded as consenting to the sexual act. This is also very, very important. Not physically resisting. So we have to remind again about that Mathura case. Not physically resisting For that, there may be very number of instances, very number of occasions why she is not resisting and all is a different matter. But then just because there is no physical resistance, you cannot take that for granted as if it's not penetration, or as if it's not sexual activity. Okay. Now, there are two exceptions that are given again at the end of 375 section. It says exception 1 is, now medical procedure or the intervention shall not constitute rape. Because delivery and all, even ladies, when they have to deliver, we do not know once the anesthesia is given, whether it is the male doctor, female doctor, who does it. We have no idea because we are already under the effect of the anesthesia, isn't it? Now, just because some male doctor is attending on you in the name of medical intervention or medical procedure, you cannot just say it's rape, because he has to invariably touch the private parts and then he has to facilitate the delivery and all. Maybe in the group of doctors who are doing the delivery, maybe in that team there may be a male doctor also. But you cannot just make a hue and cry saying that just because a male doctor was there and he was touching my body private parts, and why not I say that it is rape and all. So these are exceptions, that's what it says. Now, exception 2 is sexual intercourse or sexual acts by a man with his own wife, the wife not being under the 15 years. So if the lady is below 15 years, then naturally it is minor, it does not amount to rape. That means if she is below 15, naturally even wife also it amounts to rape. But as long as wife is not below a particular 15 years age, then you cannot just say that it is rape. So these are two exceptions that are given. And when it comes to the section 376, it is specifying the punishment for rape. Now we have to remember that I keep telling many a times that in IPC especially, the definition sections and then the penal sections, in a group of sections it will be in the same section. But there are different sections wherein the definition is given in a separate section and the penal punishment for that will be given in a different section. So like some sections, even in 375, we have two different sections, one giving the definition clause, the other one giving the punishment. So 375 is exclusively for the definition. Now 376 is talking about the punishment that can be given to the rapist. Now it says whoever, except in the cases provided for the subsection 2. That means what? Subsection 2, whatever is given is an exception. You cannot just say it's rape. It is a sexual act, no doubt, but it doesn't amount to rape. That's what it means. Like in 299, 300, we said culpable homicide not amounting to murder, culpable homicide amounting to murder. Like that, here also, though it is a sexual act, but it cannot be construed as the rape. And then one category of sections deal exclusively with the rape. That's what we have 1 and 2 clauses. So one clause says whoever, except in the cases provided for in subsection 2. That means subsection 2 is giving us a list of acts by different people, people who are in authority and all, if they use their fiduciary position, that means official position, official authority, and if they abuse that position and under their influence, under their power, if they try to exploit the employee working under them, that cannot be construed as mere rape, but then a severe punishment is also levied with it. That's what it means. So that kind of listing is given under clause 2. So for rape, they are giving the punishment as not less than 10 years. Minimum that has to be given. Minimum punishment if the case is proved, if rape is proved, punishment that can be given is not less than 10 years. It should never be in any case less than 10 years. It should be 10 and above. But which may extend to imprisonment for life and shall also be liable to fine. Now what does that mean? The minimum punishment that can be levied on a rapist is 7, at least 7, and maybe more than 7, not 7, less than 10, and it may extend. I mean, who will decide whether it should go to 10, 15 and all? Who will decide? It is the discretion of the judge. Again, depending upon the facts and circumstances of the case, then he will accordingly decide, and the discretion is completely with the judge. So if he wants to give more punishment, of course, he has to mention the reason why he is giving, though the law stipulates that less than 10 years, not less than 10 years, and then may extend. So he has to write whenever he is going for the higher end of punishment, he has to in his judgment write why he has taken such a step, reasons he has to mention. Now it may extend to imprisonment for life. See that. So if the judge is convinced in a particular case that this is a case worth fit for giving an imprisonment for life, he will not hesitate. Only thing is he'll write his reasons to derive at that particular conclusion, and then he may go to the extent of punishing him for lifelong. And then in addition there is a liability for fine also. Now the second category, he is listing out all the situations. Now under second subclass A is being a police officer commits rape. Now if a police officer commits rape, then within the limits of the police station to which police officer is appointed, maybe in his own police station. Second is in the premises of any station house. That means any police station other than to which he is allotted. Number 3 is on a woman in such police officer's custody, because they may be in custody for some other case, or maybe as a witness she is coming for a separate case. So as long as she is in the custody, now that girl or lady is accessible to him. So that's what the law is very, very wide in saying that not only in his police station where he is appointed, and in the premises of any other station house, or when the lady is in his custody for some reasons, if the police officer is doing, or the custody of the subordinate, because after all subordinate has to obey the boss, all the more the insubordination will be more in police circles, isn't it? Even if it is subordinate also, then they say it will amount to rape. Now, being a public servant commits rape on a woman in such public servant's custody, or in the custody of a public servant subordinate to such public servant. So they are giving categories. One is police officer, the second one is public servant. Now the third category, being a member of the armed forces deployed in an area by the central or state government, commits rape. Now the category that they are trying to give is, the armed forces. Now first is your police station, policeman, then this public servant, then comes the armed force. Now being on the management or on the staff of jail, remand house, or other place of custody established by or under any law for the time being in force, or of a woman's or children's institutions, commits rape on any inmate of such jail, remand home, place or institution. That means, now there are many institutions that are there under prisons. Prisons is the only one with which we are all familiar, but other than that there are other institutions like remand home, boster schools, or juvenile homes, observation homes. Like that there are a number of institutions. Now these institutions will also be manned by people, staff and all. Now the children who are, in case of juvenile, they will be put in juvenile homes. In case if they are under observation, they are put in observation home. If they exceed some age, they are put in Boster school. So like that, there are different homes, isn't it? Now, since the homes are manned by the staff also will take advantage of these children, because sometimes they are orphans, sometimes they are people who have left their houses, sometimes they are runaways from the houses and all. So these people have no guardians per se. So they will become more and more vulnerable. So that's the reason why the management and staff of such homes, they take advantage of the children, and they also at times commit a lot of and we also know for women's and then for children, women and children, there are different special home for children and all. It is also there in Hyderabad, and women institutions orphan women or deserted women or I mean this trafficked women and all. There are different homes for women, deserted women kind of a thing. So even there also they are more vulnerable because they don't have any guardian per se. So they will be the vulnerable groups, and then such homes, if somebody is trying to take advantage, even that can be punished. That's what it says. Now, being on the management or on the staff of a hospital commits rape on a woman in that hospital. Now, hospitals are also these days, no institution is an exception. So wherever the vulnerable groups are there, the staff or management or the nurse or anybody, male nurse, they will take advantage because they know pretty well that there is no defense from their side. They are voiceless, and then they don't have anybody to take care, no guardian. So they know pretty well that they cannot defend themselves. They are most vulnerable groups. So they try to take advantage, and then even if some rape kind of a thing is done to them, so they cannot raise their voice, because if they raise voice, even that kind of shelter they'll be losing. So this is little serious matter. Now, being a relative, guardian, teacher, or a person in a position of trust or authority towards the woman commits rape on such woman. See, these are also, in the name of guardian, I mean, we say incest, if it is happening within the relatives, that to close blood relatives, we say it is not rape but incest. But then any relative or guardian, if a teacher, for I mean, in most of the schools also, it's not a uncommon thing that we keep hearing that a teacher is taking advantage in the name of tuitions and all. They try to take advantage, and then they try to rape children and all. This is also quite common. So that also is included here. Now, commits rape during communal or sectarian violence. So communal violence are happening anyway. This will be an opportunity for other people, They will also make use of these situations, and then they also try to rape people and all, women and all. Commits rape on a woman knowing her to be pregnant. Now, this is a serious matter. You know that, after third trimester, fourth and all, I mean, it's so obvious that any woman who is pregnant is physically and visibly seen. Now, taking advantage that she cannot resist much and all, if you take advantage and then commit rape on a pregnant woman, that also amounts to what is known as rape. Then commits rape on a woman incapable of giving consent. Now, by her own physical vulnerabilities, if she is not able to communicate that she is giving consent and all, you take advantage of that because she is incapable. Take advantage of that, and then you commit rape on her. Then, being in a position of control or dominance over a woman commits rape on such. Because somebody may be in control of that woman, or he may be in a dominant position. If the lady is in his custody and all, if he is committing rape, then that is also punishable. And commits rape on a woman suffering from mental or physical disability. Now, incapability also they have given as a separate class, and then they also say mental and physical disability also they are giving, because the girl may be physically challenged, so her legs and hands are crippled, or she is mentally so retarded that she doesn't know what are the consequences of somebody's acts on her body. She may not be aware. So in such situation also punishment is given. Now, commits rape on a woman suffering mental and physical disability. While committing rape causes grievous bodily harm, or maims or disfigures or endangers of life of a woman. Now, this has been included, especially acid attacks are very many, and then in the process of committing rape, maybe they are creating lot of grievous bodily harm, and then disfiguring and then endangering her life and all is also very dangerous activity. Now, commits rape repeatedly on the same woman. This is also meant for repeat, as always in IPC there is a provision called 75, in which for the same offence, if a repeater is doing repeatedly the same kind of an offence on the same lady or on different people, now an extra punishment or enhanced punishment is recommended under 75. But only thing is that has to be proved. Similarly, for a repeat offender, repeat rapist also, it will be viewed very serious. So, shall be punished with rigorous imprisonment for a term which shall not be less than 10 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of the person's natural life, and shall also be liable to fine. So this is, depending upon how severe is the harm that is done, how serious is the grievous injury. So depending upon the situation and depending upon the case, because no case will give you a foolproof kind of a formula. It is only judge who will decide, fact to fact, case to case, situation to situation, it differs. So the discretion always is given to the judge in such cases to decide upon how much should be the quantity of punishment that has to be given to a particular accused will be. So that is the leverage that is given, and some sections are giving that kind of a leverage to the judge. Now fine is also imposed. Now, explanations are there. I mean, what army forces mean, what hospital means, does it include primary centers and all. I mean, for person, if they want to, especially for police and all, if they want to be very clear in applying the sections, for them it will be very convenient. And then police officer, who are all the police officers? I mean, he says under Police Act 1861, whosoever is named as police will be a police officer. Likewise, women's and children institutions, what does it include? Does it include orphanage home or neglected women? So all that, as I have already explained, these institutions, they will be collectively called as women, because some defense fellow should not take an exemption saying that since it is not mentioned explicitly in the act, so this is not a protected house, it's not a woman's house, this is not a place women normally seek shelter and all. I mean, he may come up with a lot of excuses. So just to bar that kind of exceptions, the act has taken a wide step in that. A wide category of situations and then persons have been listed in the category. Now, coming to 370, there is another third class. Whoever commits rape on a woman under 16 years of age shall be punished with rigorous imprisonment for a term which shall not be less than 20 years. See this. Age is very, very paramount. Age is very, very paramount when you talk of rape, and the tender age of the girl and all. So, under 16 years, if somebody is committing rape, now the punishment that all earlier occasions you have seen less than 10, or maybe at the discretion of the judge it is minimum 10, and then maximum can be up to life, and that too depending upon the discretion of the judge. But then here, see, straight away they are saying imprisonment for a term which shall not be less than 20. See, tender age, keeping the tender age of the victim, they say the minimum punishment that should be given in such cases, it should not be less than 20. That means 20 and above only it should, minimum should be only that. But which may extend again to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, and shall also be liable to fine. Now, they also say that there may be some amount of fine and all. And what should be the quantity of that fine also is given under one proviso. So, the proviso next says that provided that such fine shall be just and reasonable. See, depending upon the earning capacity of the accused, suppose he is a rickshaw puller, you cannot expect him to bear the cost of a corporate hospital, isn't it? So, commensurate with his earnings, then some amount, because he has committed that particular crime, as a punishment, as a fine, he has to bear that expenditure. Whatever expenditure he from his income can bear, he can only tender that much. Isn't it? So you may be joining in a corporate hospital. That doesn't mean that he has to meet out those expenditure out of his income. That's the clause. It says just and reasonable to meet the medical expenditure and rehabilitation of the victim. Now, if the girl is, she is deprived of her livelihood, or her earning capacity has been reduced and all, in such cases, just to rehabilitate her and bring back to the society and all, some expenditure is required. Or if the injuries and all are so grave and serious, then naturally she has to be admitted in a hospital, though not corporate, at least some kind of a good facility wise clinic or hospital. So there will be some expenditure incurred. Now she can't afford that expenditure anyway. Fine is been levied on this accused, so as well the fine can be given to the girl, and that will help her in at least meeting the expenditure is what is the meaning, and that is given under the provision. And provided further that any fine imposed under this subsection shall be paid to the victim. Now, instead of depositing that money in the court's account, they say that don't deposit in court account, but straight away give that whatever fine that is been levied and whatever is your capacity. Now, if you are only a small employee and all, I mean, depending upon your income facility, you can accordingly arrive at that figure, what is the amount that you would like to give as a fine. The same thing you can straight away give it to the victim is what is given under the provision. Now, coming to 376 capital A. Punishment for causing death or resulting in persistent vegetative state of victim. What do you mean? Now, in Nirbhaya and other cases and Shanbag case, that nurse case, we have seen that even if there is a survival of the lady, to what cost, to what extent? She is so fed up with her own situation that she was praying for mercy killing and all, euthanasia kind of a thing. So what is the point? You are, for the sake of existing, for the sake of living, you are living. Otherwise, you are not able to discharge your routine duties, you are not able to earn your livelihood, and you are a dependent somebody. So, such a life nobody would like to live. So, if on account of rape, if somebody died, or somebody has become a permanent vegetative, remained in a permanent vegetative persistent stage, if that stage is brought to the victim by way of rape, then the punishment that is given is mentioned under 376 capital A. That means it has come after amendment. Whenever we add capital letter after this section, it simply means that it is an amended version. So what does it say? Whoever commits an offence punishable under subsection 1 or subsection 2 in 376 and in the course of such commission inflicts an injury which causes the death of the woman or causes the woman to be in a persistent vegetative state shall be punished with rigorous imprisonment for a term which shall not be less than 20 years but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of the person's natural life or with death. See that. Now, ultimate thing that can be given to him is death. But now, if you see lot of cases, Supreme Court, Apex Court especially, it has come with a lot of guidelines. If somebody has to be given a capital punishment, and what are all the guidelines and what situations and conditions pertaining to a particular case somebody can be given the capital punishment. Then one of the criteria is the rarest of the rare. The prosecution has to prove that it is rarest of the rare category. My case is coming, prosecution case is coming under this category of rarest of rare, and for rarest of rare also they have to substantially prove in the court that these are all the guidelines under which my case is coming, and definitely it is a case fit for coming under the category of rarest of rare. So only in such cases the capital punishment is given. Now you have to bring, the court has to bring the case, that particular case under that category. The prosecution has to prove all those criteria. Only then you can say that this is a fit case for to be considered as rarest of the rape. Now, the discretion is again, whenever we say a range of punishment, then it is the discretion of the judge who is presiding over the case. It is discretion of that judge to decide whether a lesser punishment should be given or more punishment, severe punishment. And after the judgment also, when it comes to quantum of sentence or quantum of punishment, again the as a part of fair trial and all, the accused is given an option at the end before the judgment is, even after the judgment is pronounced, there is a provision that the accused is asked, now what do you say? On what ground should I reduce your quantum of sentence and all. So that provision is there. Under that provision, the accused may give lot of reasons that under so and so conditions, though I have done this crime and all, the court may be little show mercy on me, and then a less severe punishment please may be granted to me. That's the kind of plea he makes at the end. But then that plea also should be convincing. After all, it is the judge who will decide everything. The fate of the case, ultimately, it is the prerogative of the judge only. Now, he may feel that whatever reason that he is quoting may be genuine. He may reduce the sentence, but not, minimum if it is 20, he cannot reduce it to 10. सो मिनिमम तो 20 ही होगा, मगर 20 से आगे करना है, इसको फाइन भी लगाना है, कितना करना है, दैट्स ऑल अगेन द डिस्क्रिशन. एंड इफ ही इज गिविंग ए मोर पनिशमेंट, लेसर पनिशमेंट ठीक है, ही नीड नॉट राइट एनीथिंग, but then if he is trying to give a punishment at a higher end, then definitely he has to mention that in the judgment. So here in this case you see that death can also be granted, punishment as a death can also be awarded to the accused. That's what is given under that section. And 376 AB is again added, and B is added, likewise C, D, A, D, B, like that. They have added so many amendments now. 376 AB only says that punishment for rape on woman under 12 years. So earlier sections we have seen a woman under under 16 years we have seen. Now there is a special provision also which has been made to women who are under 12 years. Now whoever commits rape on a woman under 12 years of age shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to imprisonment for life, which shall mean imprisonment for the remainder of that person's natural life, and with fine or with death. See, whenever the vulnerability of the age, on account of the vulnerability of the age of the victim, so if that lady is subjected to rape and all, the act or law is very, very stringent. In that it says that if the girl's age is whether below 16 or below 12, then they say there is a severe punishment. The punishment that is awarded can go to the extent of death also. That is, capital punishment can also be levied on such accused, is what is given under 376 capital A and capital B. Now there are two provisos for that. Now proviso 1 says, provided that such fine shall be just and reasonable. So whenever rape law, if you see, whenever fine is levied, even in POXO case also, I think similar kind of a provision is there. What, Sanju, what do you say? Any idea about POXO case also? I remember that if fine is there, that should be given to the victim. Interim fine also they will levy, because by the time the case gets to some conclusion, it will be too late. And whatever minimum medical aid, first aid that has to be given to the lady has to be given in the initial stage only. They can't wait for the trial to complete. So that is the reason why in POXO also, I think I remember that. So you are doing cases, so you should be knowing the latest, what is the section.
There are guidelines. Ma'am, there are guidelines now that will say that first priority is immediate medical aid.
Even before it becomes MLC.
Yeah. And in that process, IU has to be with the victim.
And not only that, not only this fine, they need not wait till the fine thing is there, but interim relief also will be collected from the accused only. That's what I heard. I may be wrong. You can just refer.
It will be collected.
It will be collected. That's called interim kind of amount, because if you wait till the trial, it will take its own course. But then meanwhile the victim should not suffer for want of money. So that's the one kind of thing. Here also, if you see, they have used these words, just and reasonable. Now the discretion should be with the judge again. He cannot just ask for some 5-star or the 7-star corporate hospital and then you please bear, you beg, borrow and then steal, but then you have to pay the amount. That will not be that harsh. They are also reasonable people. So they fix the amount, which is just and reasonable with regard to that money. I mean, it differs from person to person. A person may be may have a high earning capacity, other person may not have that much capacity. So depending upon their earning capacities, this amount is fixed. and they only mention just and reasonable. These are the words they have used to meet the medical expenses and rehabilitation of the victim. Now, there is another proviso that it says, don't deposit this money in court and need not do that, but then straight away hand over that money to the girl who is the victim. So, these two provisos, wherever I think under 12 also they have given, 16 also they have given, whenever and when she becomes a permanent vegetative mode, if she is coming to that stage also, they said, I mean, some serious offences they have mentioned, even death is the capital punishment also can be given to such people. So that's about 376AB. Now coming to 376B, capital B, sexual intercourse by husband upon his wife during separation. That's what I was initially, when I started the lecture, I started with this. There is what is known as a decree for judicial separation. Now when the couple are not in good agreement and they want desperately to divorce each other, now court will say, now there is a cooling period, you please coolly think over it, and then separation may make the heart grow fonder, they say, proverb. So if you are separated, then you try to remember all good things which are done by your husband or by your wife, maybe there is some kind of a reconciliation. So that's what is called cooling period. So they'll allow this 1 to 2 years some cooling period, and they will only grant a decree what is known as judicial separation. Now it says, whoever has sexual intercourse with his own wife who is living separately. So the condition that is required is, it should be your own wife, she should be living separate, irrespective of whether she is under the decree of separation or otherwise. That means there is no strict rule that she should be under a decree of judicial separation. Even otherwise also, only criteria is that she should be living separate. Then otherwise, without her consent. See, own wife is number one, two is living separate, three is maybe decree of judicial separation, fourth is sexual intercourse, fifth is without her consent. If these things are there, then shall be punished with imprisonment of either description for a term which shall not be less than 2 years, but which may extend to 7 years, and shall also be liable for fine. See, this is also I mean, you may argue the thing that, when already when both of you are not in good terms, and that too when she is separately living, if she doesn't want any kind of a connection with you, and what is the reason for you? Where is the reason for you to go to her and then have sexual intercourse? I mean, that too when she is not willing. Just because she happened to be your wife and all, and you are in the process of anyway getting the marriage dissolved anyway. So, if that is the case, then what made you to go there, and then at least you compromise, withdraw that judicial separation thing, or ask in a polite way your wife to come to your residence and then have some compromise, then do whatever you want. But then without all that, without her consent, and even if it is your own wife, then it is not permitted in law, at least. Our arguments and logic will not work when it comes to legal, thing, when it is interfering. So it says that, it shall not be less than 2 years, but then see the punishment accordingly. But it's not a very big sin that they also give similar type of an offense, like they have given less than 7 years, not less than 10 years, 20 years. And that's not that serious anyway. But then nevertheless, it is against somebody's, privacy, isn't it? After all, ladies will have their own privacy, and they have their own modesty and all. I mean, when they don't want it, definitely they mean it. So that's what it says. So though not it is that serious offense, but then nevertheless you see that not less than 2 years imprisonment can be given. And of course, if the judge feels that, in the process again some grievous injury, this and that, if that there are also there additional features, then it is for the judge to decide whether to give only less than 2 years, minimum is 2 years, or should it extend to 7 years and all. I mean, it will be his liability again. Now, the fine is also imposed there. Now, in this sexual intercourse shall mean, I mean, in the 375 they have given clearly whether only when penetration of penis only amounts to rape, or if some object. And in Nirbhaya we have seen lot of after Nirbhaya, lot of changes have taken place. amendments in criminal law altogether has taken place, and then they try to expand the definition, because they also try to be so inhuman towards that girl, and then they have not, what not they have not used. So that way, so to have a wider definition to incorporate such instances also, they have given the definition of rape in a very very wider sense. So whatever, for the purpose of understanding sexual intercourse, they said whatever is given under 375 holds good also for the sake of punishment. That's what is the explanation. Now coming to 376c capital, sexual intercourse by a person in authority, whoever being. Now there is a difference in what we have seen. Somebody who is in authority, somebody who is why this 376c is given, we have to understand that difference. Now here the situation is something different. I'll read this section, then you will understand why this 376c is to be enacted as a separate section. Now it says sexual intercourse by a person in authority, whoever being in a position of authority or in a fiduciary relationship. Now fiduciary relationship by virtue of being an officer, by virtue of in a position who is authority in position. So this is called fiduciary relationship. If that is the situation, a public servant, superintendent of manager, jail, remand home, the same people only, but then only difference, see that, abuses such position, that's what is given, abuses such position or fiduciary relationship for what? To induce or seduce. That means if the lady is under inducement of, or if the lady is under seduction, then it partly amounts to consent. That is the reason why it is been given as a 376 separate. So when there is an inducement, when there is a seducement, now they say sexual harassment at workplace. I'm a lady, I should not be talking too much ill about ladies, but then these offices, and again and then men folk are too afraid, because a lot of time these sections are being abused by ladies. Now let us take an example of a research scholar working under a professor, let us say. Now a professor, by some reason, because professors try to be, they are academician, they try to be very strict, they try to prolong the scholarship, and then for scholars, when they want quick kind of a result, so within 2 years or within 2.5 years they want their PhD to be awarded. If the professor by any means, if he is a strict man and a very studious man, and then a man with morals and all, if he says 2 years, again they may say sexual harassment, this and that. This is being misused to a very great extent. Now that may be a real case, may not be that, but real cases may be that there is some inducement or under some misconception, or some mistaken notion, or seduces. They seduce her so much that she may willingly come and have a kind of a sexual intercourse. That's what we mean. That's the reason why they are given under separate section. So under inducement or under seduction, any woman either in his custody or under his charge or present in the premises to have sexual intercourse with him, such sexual intercourse not amounting to the offense of rape. They say it's not rape. It should not be construed as rape. Why they said it's not rape? Any thoughts over that? Yes? They are only saying because it's with as I said, semi consent, because inducement is there, seduce is there. So that's the reason why this has been given as a separate separate section altogether. And they are saying that it doesn't amount to rape because there is a partial consent in it. If there is complete total non-consent, then of course rape. But then under special conditions, like they are taking advantage of their position, one, and they are also taking advantage of their fiduciary thing. So based on these things, So if somebody is taking advantage, abusing their power and all, they say that it is not rape, though not rape, but then punishable. Nevertheless, it's a sexual intercourse only. So this will amount to a sexual intercourse, but not under the category of rape, but then there is punishment also that is given. What is the punishment? Shall be punished with rigorous imprisonment of either description for a term which shall not be less than 5 years, but which may extend to 10 years and shall also be liable to fine. So depending upon the situation and depending upon the person who is under whose authority this victim is living, and whether it is a fiduciary relationship, whether half consent, semi consent, or consent under inducement or seduction and all, so accordingly the sections are different, and punishment that are levied on such accused are also different. Now, it also has got 3-4 explanations under that. In this section, sexual intercourse shall mean, same thing, what is the definition of sexual intercourse and all is given already under this definition 375. Now, for the purpose of the section, explanation 1 to 375 shall also be applicable. Now, superintendent and all, you will have the same meaning again. Now, for remand and women hospital and all, same meaning, because everywhere they give the explanation so that we will not get confused. Unless until it carries a different meaning, they did not give, but I don't know, by abundant precaution, they are also giving us again explanations. Then, 376 capital D. Now, gang rape. Where a woman is raped by one or more persons constituting a group or acting in furtherance of a common intention, each of those persons shall be deemed to have been committed the offence of rape and shall be punished with rigorous imprisonment for a term which shall not be less than 20 years, but which may extend to life, which shall mean imprisonment for the remainder of that person's natural life and with fine. See this. Now, this is they are including the common intention kind of thing. What do you understand by common intention? This we have already discussed. Common intention, if you recollect. Now, gang rape, it means more than one person is coming into picture, isn't it? Now, how will you fix the criminal liability on each of them? That's what matters. Under 34, if you recollect, under IPC, if you recollect, they have used the word under explanations, they have used common intention. What do you understand by common intention? If there is a gang, if there is a group of 2-3 people and their motive is same, and then they have a consensus of mind, they have decided upon doing a particular act, each one communicate to the other, so they share their views and they plan how to commit that and all, they already share before committing the crime. So if that kind of thing the prosecution can establish, even if the other person among the gang, one may be actually doing the rape, the other person may be holding hands, isn't it, or maybe holding legs and all, the other person may be undressing the lady, immaterial, as long as they are participating actively. Somebody may be waiting outside so that if anybody outsider comes, he can give some signals and signs. So even that person can be said to have participated in the crime. So common intention in furtherance of a same goal means even 34 section gets attracted there. Apart from this 376, when you use the common intention, read with 34 IPC also will come into the picture. So if she is let us say a woman, and then a gang rape is there. Now even if among the gangsters, if one or two are not doing any rape actually also, they will be treated as if they have done that particular act. Why? Because we have to attract that 34 section also here. Now, I hope I made the section very clear. Arya, because Patil I think has left, are you able to understand this?
Yes, ma'am, yes.
Now, this is about 376D. Now, 376 capital DA is also there. Punishment for gang rape on women under 16 years. See the tender age. Whenever 12 years, 16 years kind of a age, if we can establish of the victim, then there are more and more severe punishments for that. because 16 years is such a small age, and then rest of her life, whatever she is to whatever extent she is going to live, that trauma she has to carry, physical, mental, whatever trauma, injuries and all, she has to carry throughout life. And 16 years in a life of a lady or in a life of any person is too small. But rest of the life, how she has to survive? So for that reason, the punishment, if a gang rape is done on a girl below 16 years, is also similarly, it has to be taken as serious. Now, uh, shall be deemed to have been committed common intention, because it's a gang rape. Whenever there is a gang, one or two people, you have to attract that common intention thing, 34 thing. Now, shall be punished with imprisonment for life, which shall mean imprisonment for the rest of the life of the person's natural life, and also with fine. Now they are also again saying, whenever they say fine, you have to fine is fixed as per your income, and it is just and reasonable, and whatever fine that is been levied upon you, please give that to the victim, so that she can rehabilitate, and then she can also meet her medical expenditure, is what is given under the provisos. And coming to 376 capital DB, punishment for gang rape on women under 12 years of age. Now what is the punishment? गैंग रेप भी हो गया, और बच्ची का उम्र भी 12 ईयर्स के अंदर अंदर है, सो उसमें तो पनिशमेंट अलग ही होता. व्हाट इज द पनिशमेंट दे आर अगेन सेइंग. नाउ हियर आल्सो व्हेनेवर वी से गैंग, you have to attract that common intention thing, 34 thing. So please read that section also, 34 under IPC talks about common intention. Now, each of these persons shall be deemed to have committed. There is a deemed clause, legal fiction. Deemed means irrespective of whether the one of the gangster is actually doing the rape or not, irrespective of that, as long as he is physically present, he is doing, actively participating in some work or the other towards that, towards achieving that rape, he is liable. Same kind of criminal liability will be there on all the people. That's what you have to understand. I mean, they need not, if they take a plea that no, I have not participated in actual offense, I have not committed rape, anything, I was only asked to guard outside, and apart from that, I have not done anything. If the other person tries to take this kind of a plea, that's not allowed squarely. Why? Because we are attracting the common intention. Common intention simply means that anything which is done in furtherance of that. What is the furtherance of, what is the offense here? Offense is rape. Furtherance of rape, they are doing any act because they are physically present, there is a consensus, there is an agreement, all of them decided what exactly they have to do, what is the role played by each of them, this is all understood. So even if the other person has not committed anything, but then he is physically present and then he is doing something towards the commission of the rape, then he is also liable. The same kind of criminal liability, if suppose the one person is given 7 years imprisonment, the other person will not be exempted from that. He will also be given the similar kind of a punishment, is what is meant by common intention. Now, 376E is talking about the punishment for a repeat offenders. Now, why you think that repeat offender, irrespective of whether it is a case of murder or whether it's a case of rape or assault or whatever, why do you think that a repeat offender, there should be a separate provision, and what should be the punishment? Should it be the same as that of a single time offender or a repeat offender? Do you think that should be the same?
No, ma'am. Some more serious punishment should be given for a repeat offender.
Because the purpose of any punishment is deterrence, isn't it? The other person who even have the idea of at least committing such a type of offense should withdraw from that idea. Why? Because उन्हों करे तो उनको इतना सजा मिला, हम करे तो क्या है, उन्हों बार बार वही काम कर रहे, वही अफेंस कर रहे, इसके लिए तो बहुत बड़ा सजा हो रहा, तो हम भी क्यों करना, बल्कि that kind of a deterrence will be there. That is the reason for a repeater always for the same offense, even if it is committed on the same lady or repeat offenses on different ladies also, there is a severe punishment, additional punishment. So what is that? What is that? It is mentioned here. Now, it says for all cases that we have mentioned, A, D, B and all, It says, is subsequently convicted of an offence punishable under any one of the said sections shall be punished with imprisonment for life. देखो इसमें तो straight away minimum that's what is given is life, which shall mean imprisonment for the remainder of that person's natural life or with death. देखो, so wherever we talk of severe punishment, something the judiciary or the lawmakers have in their mind. That means either the offence should be too harsh or too severe or too dangerous, or the victim's age is also too tender. If it is minor and below 16 years, below 12 years, so wherever such clauses, wherever you see the predicament of the girl below 12 years or below 16 years or minor, they say punishment is severe. So the quantum of punishment, as you can see in any other sections, it is proportionate to the harm that is being done. Even in RPD also we have seen. So punishment or harm that is done to your own body, if you want to retaliate, your RPD should also be to that extent only. It should never exceed, isn't it? So similarly, for a repeat offender, and when you compare it with the first timer, now first timer you are giving some kind of a leverage that second time don't do it, because first time only you have undergone such a rigorous imprisonment that this punishment at least should deter you from committing any further offense, or it should not make you do the offense again and again. So that was the promise with which they have released him after undergoing the punishment completely. This is the hope with which they have let him go, isn't it? Now again he is defeating their hope, and then he is doing the same offense again and again. That should not be spared, because at least others who venture to do the same kind of an offense, they should be they should receive this kind of a warning signal. What is the warning signal? If somebody does a repeated offense, this is what they get. So let me also not do it, because I will also meet with the same kind of a situation. So this kind of a signal should go to the offender. For that reason, they say even if it means life imprisonment and also death, because minimum itself is starting with the life imprisonment, if you see this section, and maximum is death. And of course, as I said, whenever maximum kind of a punishment is being awarded, the judge should be cautioned enough, because in a fair trial everything should be very unbiased and everything should be so transparent. Now I cannot just because the power of giving punishment is there in my hand, I should not misuse my power, isn't it? Why I have come to such conclusions? If I give logical reasons or the substantial statements for that, then even judge should also, he is not above board, and he is also a public servant doing his duty and all. So whatever work he does, it should also be just and reasonable, isn't it? So the same thing applies to everybody. Now if it is a severe higher kind of a punishment, then definitely the judgment you do find that the reasons why, though the minimum punishment that is there for this particular offence is only below 20 years, shall not exceed 20 years, but then I am giving a life imprisonment for him. Why? Because this several occasions he was very rude and all, has done this, and he is a repeater. Like that, he has to give a lot of reasons for that. Why he is awarding a severe and more punishment for that. The judge is supposed to give these reasons. So this is under 375 we have completed the definition sections. 376 talking about the penal sections. Under that we have seen several categories, like age is one factor, then gang rape is another factor, then somebody taking advantage of the public authority, that cadre. So remand homes also we have talked about, women, children's house, jails, prisons, all that we have talked about. So 376 got over now, and there is one more section left, which is called the unnatural offences. Now, as the name implies, unnatural offences are given under the section 377. Now, as we know, unnatural means against the nature of law. Against the nature of law. Nature permits only certain kind of intercourses, and they are legalized. If you have an intercourse, with sexual intercourse with your own spouse, They never said, no, no, don't procrastinate, don't have children and all, you please be married and then live like that. Nobody says that. But then there are legal permission, legal sanctions to some sexual intercourses, like wife and husband, it is legally sanctioned because you have to beget your children and all, that is permitted. And your wedding is a lawful wedding, and then subject to all that, it is permitted now. That is granted by the law. So they are all natural kind of sexual offences. I mean, what amounts to unnatural is given under 377. It's both definition clause as well as the penal clause. We don't have a separate penal clause for that. Both are given under the same heading of 377. Now, whoever voluntarily, that means voluntarily because on his own accord, voluntary means on his own will. Nobody is forcing, on his own will. With all his conscience, he is doing that. Now, has carnal intercourse against the order of the nature. So, this nature also doesn't promote. An intercourse man with man is not allowed. But homosexuals and all is a different story altogether. But we have a different law altogether. And then, that gender as a third gender and all, we try to bring in lot of things against nature, that's a different story. But then here it is given as, against the order of the nature, against the order of nature. Now with a man, man with man, and woman with women, isn't it? Lesbians and all, and there are categories of people. So, or animal shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable for fine. Now, if somebody reports, all these cases, they happen in privacy, isn't it? Now, if the other party doesn't report, see, for example, they don't report, that means nobody reports, how can a case be made out? Only when it is reported either in police station or in before the magistrate, then some legal force will come to it and they will be in a position to take action, isn't it? Now, if the agent, passive agent, is silently suffering, they don't want to report, then how can somebody take action, isn't it? Because they are such a type of crimes which happen in privacy. It will never happen in public, isn't it? So that's the reason even police or the magistrate, they'll not be able to notice that kind of offences. Now, if somebody, the passive agent comes and reports, for example, in most of the time, jails, what will happen, because the hardcore criminals, they will be put behind bars for life, isn't it? So, if they, because they also have this lust, so they have to somehow get their lust done. So what do? They take the tender age of the boy. If suppose a boy is also kept, that is the reason for juveniles, after juvenile act and all, they try to keep them in a separate home. Otherwise these hardcore criminals will take advantage of them. So anal intercourse, any kind of thing, because they are so crude and they are so fanatic about that. So they do this kind of a thing. So that is the reason why they said the passive agent, like that small boy, if he can go to gather courage and go to the magistrate or the police, and if they can say this is what they have done, so they can book the case under 377, unnatural offence, isn't it? Now, animal. See, animals, why? I mean, not in civilized, urban kind of setup, they do this kind of a thing. But then rural scenarios, there is a lot of myth among rural folk. What is the myth? If somebody is AIDS affected, if somebody is having that HIV kind of a thing, they have a wrong notion that if they do intercourse with an animal, then they'll get rid of that AIDS and all. So I don't know why this misconception, but that's very prevalent. This may look very silly and all for people who live in urban setup, but then it's quite common in rural setups that, somebody under this misconception try to do intercourse with the animal and all. Of course, animal will not come and report, but then if somebody notices this and all, and if somebody as a good citizen, if somebody comes and reports, then that can also be taken cognizance, and that person can be booked under 377. And then for that you have to medically also collect some evidence. The doctor conducting the examination of the accused should also examine his private private parts, and then some animal hair, some animal fecal matter, and all these kind of things will be a corroborative or circumstantial kind of an evidence that will strengthen the prosecution case. This is what we have to understand from this. Now explanations and all, again, for penetration, what is sufficient and all is given in the explanation. So with this, I think rape law also is over. We have completed the entire portion, and from next week onwards, if you have time